Hello, I'm attorney Len Spada. Thank you for visiting our website. The purpose of the video today is to explain to someone who's been injured and is thinking about pursuing a personal injury case, to explain to them what it entails, what they can expect, so that when they meet with an attorney, they have a much better understanding of the whole process. My initial interaction with clients is usually either through a website visit where they're chatting or a phone call to my office. It's important for clients to know that during that initial telephone call, it's free. There's no obligation to hire our firm. There's no cost involved. You can call and get answers to some of your preliminary questions. Once we've had a chance to speak on the phone, we'll have a sense of whether or not it makes sense to take the relationship on to the next level and have an in-person meeting. There's much that we can learn through an initial phone conversation that tells us whether or not it's going to be fruitful to have another meeting. We ask over the phone some of the basic questions: what happened, how you were injured, some of the facts involving the accident, whether it be a construction site accident, a car accident, a slip and fall, a dog bite, whatever the case may be. There are preliminary questions that we can ask to get right to the bottom of whether or not this is something that you might want to pursue or it's not. We're very honest, we're very upfront, and that initial contact is important. But please remember, it's a free call and there's zero obligation, so don't hesitate. Get your questions answered. If after that first interaction, whether it be through the website or a phone call, we determine that it really makes sense for us to meet in person, we'll try to schedule a meeting here in my office. Now, sometimes that's not possible. Many of our clients are very seriously injured and they can't make the trek to a law office. We understand that, and we will accommodate them. We will go to their home. We will go to a rehab center if that's where they are. We've actually met clients in hospitals if they were going to be in for an extended period of time. We make it convenient for the client to talk to an attorney and get to the bottom of whether or not they can pursue a claim legally. Once a client comes into our office, there's many questions that need to be answered before we can begin working on the case. For example, I'll use a car accident as an example, but it holds true regardless of the situation. If somebody's involved in a car accident, we are going to ask questions about who the other parties were, whether or not there's a police report involved, if we can find out whether or not the other party involved has insurance or is uninsured. We'll ask questions about our clients' individual insurance policies, car insurance policies, because that may provide coverage. We will ask questions about their medical treatment, who their doctors are, what type of health insurance they have. These are all facts that, as we work our way through the case, we need to know. And many of those answers come from the first meeting. Now, we recognize that there will be many questions that a client simply cannot answer. A client may come to us, and again, using a car accident as an example, may not have a police report, may not know the information about the other driver, may just have a license plate number. We don't expect clients to have all the information, but it is our job to get as much information as we can from the client at that initial meeting. That initial meeting often takes probably an hour to an hour and a half. And during that time, we will ask at some point to have certain documents signed which give us permission to continue on in our investigation. It's the purpose of the first meeting to figure out whether or not an attorney-client relationship can be established, whether or not our firm can help the client recover damages for his or her injuries. If we determine that we can during that first meeting, we will need certain documents signed by the client so that we can move forward. There's several documents that are almost always necessary. The first is medical authorizations. The client is injured. We need to document the file so that we can prove later on exactly what those injuries were. We need medical records. We can't get them without a specific authorization from the client. So we'll have the client sign several of them because there's usually more than one medical provider involved. We'll also need to know whether or not the client missed time from work, whether or not they lost any earnings as a result of their injuries. If so, We can't get any verification from their employer unless we have a signed authorization. So we'll ask for those as well. Finally, at the conclusion of the first meeting, if an attorney-client relationship is going to exist, we need a contract between the client and the law firm as to how we get paid. That's called a contingent fee agreement. And the way it works in almost all personal injury cases is that the client pays nothing up front and never has to go into his or her own checkbook to pay a lawyer. We get paid by recovering a percentage of whatever it is we can collect for the client. Simple example, it's simple math. We typically take 1/3 of the gross amount that we recover for the client. If a case settles for $100,000, our fee would be $33,333. Now, are there exceptions to that 1/3 rule? There are. There are occasions where the work that we do doesn't warrant a full fee. There are cases where we take a case all the way to trial and appeal, where a 1/3 fee would get increased to slightly higher, possibly a 38% fee. But that's all explained at the first meeting prior to the client signing anything. But the vast majority, I would say 99% of the times, the fee structure is 1/3 of the gross amount recovered. At the conclusion of the first meeting, each client is assigned an attorney and a case manager to handle their file. They will always have an attorney and a case manager that they can contact regarding the status of their case. The case manager will meet the client at the initial meeting. The attorney will meet the client at the initial meeting. That case manager's responsibilities involve all administrative proceedings. Making sure your medical bills get paid, making sure that all your medical records are obtained and that there aren't loose ends as the case proceeds. A case manager will stay in frequent contact with the client, either by phone, in person, or by email. There is much communication between the case manager and the client. The attorney, however, may not always be in the office. He may be in court. He may be at depositions. But the case manager does not travel, does not go to court, is always here to answer questions. So you'll meet the case manager at the time of the first meeting. Now, what happens after the first meeting? We've established an attorney-client relationship. Now the real work begins. There's much to do from our point. What we need to do initially, and it's usually either the same day that we have the meeting or the next day, is that letters from our office need to go out to the at-fault party, whether it be a car accident or if it's a slip and fall, the property owner, or if it's a construction site, whomever the general contractors are, etc. A letter will go out from our office indicating that we represent you. And that letter is extremely important. It does several things. First, it stops any communication between the at-fault party and his or her insurance company and you. It's our job to make sure that you can focus exclusively on getting better, worrying about your injuries, not worrying about paperwork or phone calls. That first letter stops any harassing phone calls from an insurance company or the defendant themselves. During the 1 to 6 month period after the accident, a case manager will also begin to monitor closely the client's medical condition and medical treatment. The case manager will, on a very regular basis, communicate with the client. Where are you going to the doctor? What type of treatment are you getting? Give us the name of all the providers. We keep a constant tab on medical progress so that we can continually gather records that we need to substantiate our client's claim. Now, this is the point where a case manager and the client work very closely together. We don't know what a client is doing medically unless a client tells us. Now, we recognize and we sympathize that clients in the process of rehabbing and getting treatment aren't about to call their lawyers every time they have a new doctor's appointment. It's incumbent upon us to reach out to the client and say, hey, Mrs. Jones, how are things going? Can you give us an update on what your medical treatment's like? It's up to us to do that, and we do it frequently. so that at the end, when a client has reached a medical endpoint, we've gathered all the information we need and we're ready to hit the ground running with trying to settle the client's claim. Also, during the 1 to 6 month period, in addition to gathering liability information and medical information, we really want to know what the human effect is. What's going on with the client's life? How has the client's life been altered and disrupted as a result of the accident and injuries? This is crucial because a component of damages in a personal injury case is pain and suffering. And what that means is how a client's life has been impacted. It's one thing to say a client broke his or her leg in an accident, but it's another thing to talk about how that broken leg has affected that person's ability to do daily activities at home or to enjoy a son or daughter's sporting event because they can't walk or they can't drive because of the injury. These are all personal issues that we need to elaborate on, and we can only do that if we can elicit information from the client. That involves time on the phone with the case manager and the lawyer. We need to ask a lot of questions. Sometimes clients will joke that we ask too many questions, but that's the way we get to the bottom of how a case impacts them. And that's the difference between settling a case for a very modest amount or settling a case for the full value. And we endeavor in each case to get the full value for a client, and that involves what's going on in their life. There are very, very, very important details that need to be addressed that we can only do with constant contact with the client. Also, during the 1 to 6 month period, we need to know what's going on with their employment. If a client has missed work, we need to know why. We need to make sure that there's medical substantiation for the time out of work. That'll involve us contacting medical providers to get out of work notes. It'll involve contacting the client's employer to find out what their rate of pay was, whether or not they had to use vacation time, etc. So there'll be communication with respect to lost earning capacity if that's in fact an element. There are some clients that don't miss any work as a result of their injuries, but many, many do. At some point, a client will reach what we call a medical maximum endpoint. Simply put, that means that the client is completely recovered and back to his or her baseline health condition, or despite additional medical intervention, they will never get back to that point. So they are either completely healed and back to normal, or they're as good as they're going to get. Unfortunately, many of our clients have some permanent residual deficits as a result of their injuries that they never get back to baseline. Some do, but many do not. And when a client reaches this critical point, meaning they're at their medical endpoint, we begin to put the case together in an attempt to try to negotiate a settlement for the client. Because I've met very few clients who choose or desire to go to court and to trial versus trying to settle the case. So although we handle each and every case like we have to go to court with it, it's ultimately our goal to keep the client out of court and get the case settled. Now, there are times that's not possible and we go to court, and we're going to discuss that in a separate video. Now, in Massachusetts, on a typical injury case, you have what's called a statute of limitations. In a car accident case, for example, you have 3 years from the date of accident to the statute of limitations date where you must either settle your claim or initiate a lawsuit. You have 3 years. Now that's important because, believe it or not, some clients do not reach a medical maximum endpoint inside that 3-year statute of limitations, and we therefore are forced to take the case into suit or to try to settle it for an amount that the client deems acceptable. But something needs to be done within those 3-year period. If a client reaches a medical endpoint prior to the statute of limitations, prior to the 3-year date, we try to negotiate a settlement. And what we do is we gather all the client's medical records, we gather all the client's employment information that we've periodically been recovering through our case managers, and we put together what's called a settlement demand package. With input from the client and information about how their life has been impacted by their injuries, we'll submit something that's called a demand package to the insurance company. That demand package includes all the medical records, all the bills for the medical records, all verifications on lost earning capacity claims. If there's scarring involved, it'll often involve or include a report from a plastic surgeon with respect to scarring. Any type of permanent disability will be addressed by a doctor. We'll attempt to get a permanent disability rating from a doctor that we can use in our demand letter. The demand letter is essentially an outline of the case for the insurance company. It's written as persuasively as possible. That's why during the pendency of the case, we speak to the client so often to try to find out what's going on in their lives so that we can incorporate it. Our job is to present as persuasively as possible the client's plight. We need to express in writing exactly how the client's life has been disrupted. That's a difficult task, but it's something we do on a daily basis, and it's something we do very well. At some point, after the insurance company receives a demand letter with the package of medical substantiation and earnings and photographs or whatever else we need to prove our case, we'll have communication. This is where a lawyer will get involved. We will speak to the adjuster, who is the person at the insurance company responsible for trying to resolve the case if possible, and we'll begin to negotiate. It's important to note that the attorney is not authorized to settle the case without first speaking to the client and getting the client's explicit consent. When we get offers from an insurance company, we don't say yes and we don't say no. We tell the insurance company, we will get back to you. We then present to the client, typically at a meeting, a sit-down meeting, here's what the insurance company is offering. This is what we think of that offer, and we give them our advice. They're paying for our advice. Once a client has our advice and makes a decision, it's the client's decision if they choose to accept the offer or if they choose to decline the offer. But they will do so either way with our full advice. Assuming for the purposes of this video, they agree to settle the case. Client will come in, we'll discuss the amount offered, we will have them know to a penny what's coming to them, what's going to the firm, what's going for expenses, etc. They will not leave our office without knowing to a penny what they get. Any expenses that we've made on their behalf are detailed. They'll get a listing of them. They'll see what we spent money on, what we're asking to recover. There's no guesswork, so that when the client's case ultimately settles, they'll sign a release indicating to the insurance company that this is final. We'll send that off to the insurance company, and typically within 2 weeks, a settlement check will come into our office. That settlement check will be made payable to the client and to Spada Law Group as his or her attorney. We then deposit that check into an escrow account. An escrow account is a separate account drawn on our firm, and that's where the check waits to be cleared. When the money is cleared, the client then is dispersed their portion of the settlement. Spada Law Group is dispersed their fee and expenses. Again, this is all detailed. There are no surprises. By the time this happens, the client has a piece of paper in front of them that they sign. That's called a settlement breakdown, where they know exactly where every penny is going, and they get a copy of the initial check that came in. It's important to note that approximately 90 to 95% of the cases that we handle ultimately settle without going to court. However, in our next video, we discuss what happens when cases don't settle. What's the process of going to court to try to resolve a personal injury case? So hopefully, if you have questions with respect to cases that don't settle, please tune in. And again, thanks for visiting our website.